ferocities of some kind of upheavals in the judicial benches. Recently, Supreme Court has said rotten High Court. It has its own purpose, meaning. It is not a criticism. It's sounding well what we are. Are we doing the right thing? Do we lack anything how to overcome? Yesterday, in the media, a 30 years old boy, young boy, questioning left and right. I felt uncomfortable for one reason. Not aware of the strength and purpose behind the words rotten. Superfluously ordinary man, he thinks in different way. But fraternity from the legal world, he understands. It's only improvement. By public interest litigation, so many cases are coming, particularly corrupt practices. For example, in Australia, in the case of Louis Ross versus the Commonwealth, when we take a decision, when the Honorable High Court of Australia, the public doesn't appreciate, so they wish the judiciary must abdicate its responsibility. The criticism should not lead to the abdication. Similarly, in the UK, the Burma case, where the judiciary tried to sound something is wrong, immediately they brought legislation to nullify the effect of it. Other more important, the Marbury versus Madison. I looked at this. Marshall is an opportunity of convenience. He had to bring the new concept of judicial review, judicial power, just to safeguard his appointment as a Chief Justice. That kind of convenience of opportunism, if it removed, the judicial accountability can be enforced upon. For that, I would like to suggest only one thing, a regular interaction between the executive and legislation. The judiciary bench, they can go and attend the seminar conferences presided over the Speaker of both the houses, and the Chief Justice can also be party to them. It is possible through the Select Committee of Law and Justice. We need not create a new enactment, new legislation to curb the independence of judiciary. The Parliament doesn't work or not, we are seeing pandemonium currently. The government has to work, the people have to live. Justice has to take place. The executive, with enormous powers, with a highly trained skill and technicalities knowing aware of it, they can twist the decision in favor of an individual or a group. So somebody has to build a cadre, only judiciary can. We have to strengthen independence of judiciary, not at the cost of Parliament or the executive. At the same time, we need not be necessarily going against the mainstream of the dynamism. The society is looking for development. If we are pulling back, that is what the biggest criticism against the judiciary is. The executive always make the statement, they don't understand. They don't have strong skills and caliber. They are not qualified to make judgment on very, very complicated issues on expenditure of sources, etc. It's only a matter of concern for everybody. At the same time, the last I'd like to make, the eradication of corruption. The eradication of poverty, the judiciary only has done it. Now, the time has come. All three limbs of the governance have to work together to eradicate corruption. The corruption takes in four forms. Induced corruption for particular group of individuals or a MNC or corporate sector, a community, a class, just to enrich their economic welfare or social status or political prosperity. they try to influence every arms of the power, governmental power, governance, by way of inducement. At the same time, the persons in the government power can also induce the person to fall prey to that inducement of corruption. That has to be called. Then inactive corruption. This very silent. If you walk down to the railway stations, साहब इनको 10 रुपये दिए तो बर्फ मिल जाएगा, 100 रुपये दिए तो बाबू कागज दिखाएगा. See, just it has become inactive because everywhere you go to the revenue authorities or any, even in the judgment copy to get, the babu demands something inactive corruption. This has to be corrected upon. Then irregular corruption, the recent Commonwealth episode, 2G, Spectral, all these things are irregular. Occasionally it comes in a huge way. How to the successful strengthened separation of powers can eradicate corruption? A strong parliament can only do it. A sound executive power can only do it. An independent judiciary can alone eradicate this corruption. This is the foremost issue before every country, particularly India. With that, I thank everybody, the organizers and the fellow participants. Thank you. Bye.
Now I call upon Dr. M. Asad Malik, Assistant Professor, Faculty of Law, Jamia Millia Islamia, to come up and give a...
Ladies and gentlemen, I will discuss on this relationship among judiciary, executive and legislature. Only 5 minutes has been allotted. It's very difficult. First of all, I would like, as the earlier speaker told, the doctrine of separation of power is an essential feature of all modern constitutions of the world. And this doctrine has been originated in England, but there is no separation of power because of the parliament sovereignty. Only constitution of the world, that is the America. There are 3 articles, first, second and third, talks about this separation. But ultimately, this is no rigid separation of power. Ultimately, the checks and balances has been followed in America also. So far as India is concerned, I will talk about this historical background. There is no need. Only Article 50 that partially talks about this. 3 cases decided earlier. As the sir told, in the Delhi Laws Act 1951, Ramdevaya Kapoor 1955, Ramkrish Dalmia Justice and Local 1959. All these 3 cases, the Supreme Court of India held that this is not a part of our constitution. Rigidity, there is no rigidity, but it is a separation in India. But Keshavananda Bharati and onwards, that is a basic structure of Constitution of India. But in present time, the question of this relationship, because it is to be said the one organ is encroaching the field of the other. It is based on the power corrupt and absolute power corrupt absolutely. Because of this reason, the all power should not be concentrated in one organ of the government. But here it is to be said in the name of the judicial activism, whether the judiciary is overreaching the field of the other, whether it is required or not. This, if we will see the provisions of the Constitution, there is a relationship because every organ works with the other. For example, Article 53 only talks about the executive power vested in the President of India. No other article of the Constitution talks about that legislative power vested with the Parliament or judicial power vested with the Supreme Court or High Court. Because the legislative power with the Parliament or state as Article 245 and legislative power in the Supreme Court or other. Powers can be delegated to the executive also, and judicial tribunals also working the judicial function. So it means there is no separation. The other are executive also performing judicial function, judiciary performing the executive function. It means there is something, or there is some overlapping here also. Recently I will discuss only the 3 cases and thereafter I will give my suggestion. As this G. Singh versus State of UP, 2007, 586, this Justice Margande Kadri in this case clearly held the judiciary should work within the self-restraint, judicial restraint. That should also be treated as a judicial respect. Because if the judges work like a legislator, then the judges should be elected. Why they should be appointed? We don't have expertise. Recently, 2 days back, the High Court of Delhi gives a very good example when this High Court said that the NET and SLAT is the mandatory for the appointment of the lectureship because it is not our arena, it is the matter of the accommodation. There is no need to interfere. And thereafter I would like to mention here Aravali Golf Club case, State of Haryana, 2008. In this case also, this Supreme Court of India held that if there is balance has been disturbed, Because if one organ will interfere with the other, then the variance will be disturbed. In this case also the court held that the main plea is that if the two organs of the government is not working well, because of this the judiciary is interfering. The judge said that the same question can be asked from the people or the organs, because if the judiciary is working well, why dependency is increasing day by day? So we have to work within the limits. And thereafter recently in 2010, University of Kerala versus Principal College 2010, also the Supreme Court, Justice Markandeya Karju held that the separation of power is a part of our constitution and the judiciary should also work within the self-restraint. But here the question is whether we are living in the largest democracy of the world, where the people participating in the election, casting their votes, electing their representatives, having the some expectations from these organs. Particularly the executive and the legislature should fulfill these expectations known as the legitimate expectations of the people. If the prime organ of the government, legislature and the executive is not fulfilling these expectations, then the question is who will fulfill? Then it's the judiciary. Judiciary should come forward. Particularly when these expectations of the people is not fulfilling well, then the judiciary should come forward. Why? Because in India the judge is treated second to God. The people having the more faith in judiciary. But unfortunately in present time, all the legitimate expectations of the people turned down in the name of the corruption everywhere prevails. Because in legislature, in executive, somehow as the question also raised about the judiciary. So first of all, it is necessary, as these are told, that the corruption should be eradicated. And these particular legitimate expectations of the people, those the people have, should be fulfilled. Thank you very much.
Honorable distinguished guests, guests and friends. The principle of separation of power is based on the maxim absolute power, perhaps absolution. This principle of separation of power has not been emphasized in clear terms in our constitution, but relates to mutual relationship among three main organs of the government, namely judiciary, legislature and executive. Apparently in broad sense, it seems prima facie that our constitution is based upon the doctrine of separation of power. Judiciary is independent in its spirit. Neither executive nor legislature can interfere in its spirit. To strengthen this independence of judiciary, the Constitution restricts the legislature from discussing the conduct of any judge in the parliament. The function of judiciary is not only to impart justice, but also to act as a watchdog. The Supreme Court or the High Court has the ample power to interpret the laws made by the legislature and declare any law as void if it is found to be unconstitutional. The legislature is empowered to legislate laws. The privileges and immunities granted to its members are immune from judicial scrutiny. The President is the executive head. All the executive functions are done in the name of the President or the Governor. The President or the Governor also enjoys immunity from civil and criminal liabilities. In this way, in broad sense, it seems that our Constitution is based on the doctrine of separation of power. But in a strict sense, this doctrine of separation of power has not been awarded a constitutional status. Generally, the legislative power has been entrusted to the legislature, but under some specified circumstances, the President is also empowered to exercise legislative functions by way of issuing ordinance and formulating laws while proclamation of emergency is in force. President also performs judicial functions. The executive powers vest in President, but in real sense, Prime Minister along with his Council of Ministers is the real head who is responsible and answerable to the Parliament. Similarly, Parliament, in matters of breach of its privileges and in case of impeachment of President or the judges of the Supreme Court or High Court, it exercises judicial functions. Similarly, judiciary exercises executive or administrative functions when it supervises the subordinate judiciary. It also exercises legislative functions when it formulates rules regulating their own procedure. In other words, our Constitution does not follow the principle of separation of power in absolute term. Rather, it is based upon the principle of fusion of powers. In fact, we have adopted the principle of separation of functions and not of powers. The theory of separation of powers is not part and parcel of our Constitution, but even then, except where the Constitution has vested powers in a body, the principle that